Good afternoon, and thank you for joining us on this rainy and cold day in Washington. I'm Gary Schmidt. I'm a resident scholar here at the American Enterprise Institute and director of AEI's program on American citizenship. We're here today to discuss President Obama's recent decision to extend protection from deportation and extend the right to work to an estimated 4.1 million illegal aliens who are parents of U.S. citizens or legal permanent residents. Although it's inevitable that we'll be touching upon the policy implications of that decision, our primary focus today is on the issue of whether this decision by the President was constitutionally appropriate and constitutionally appropriate use of his President's executive power. Was this, in short, a reasonable assertion of the President's independent executive power, or, as some have argued, a violation of his duty under the Constitution to faithfully execute the laws? Joining us today to discuss this issue and its broader implications are Ross Stout, columnist for the New York Times, the author of 3 very marvelous books, with the latest being Bad Religion, How We Became a Nation of Heretics. Anyway, I asked Ross to join us today since before the President's decision was announced and when there were news leaks about what he was planning to do, Ross penned a New York Times op-ed with the title, quote, "The Great Immigration Betrayal," describing the President's decision as a power grab, and precisely the kind of power grab that the former Senator and candidate Obama had once criticized the Bush White House for engaging in. Next up will be Bill Galston of the Brookings Institution, professor at the University of Maryland, and former domestic policy advisor to President Bill Clinton. Bill is also the author of several important books, not all, but mostly on modern liberalism. I've been reading Bill's works for 4 decades now. As a matter of fact, I remember sitting in the stacks of the University of Chicago Library reading his dissertation back in the mid-'70s, which of course means that I was only 12 when I was doing it. Bill is also a columnist for the Wall Street Journal, whose op-ed, quote, "The Law is with Obama on Immigration," was written shortly after the President's announcement. And obviously Bill has a different take on the President's decision. Among other things, he cites recent and past Supreme Court decisions as supporting wide executive branch discretion in these matters. Our format today is pretty straightforward. I've asked Ross and Bill to speak for about 8 minutes. And then we'll probably have a bit of a discussion back and forth between us. But I do want to give you in the audience a chance to ask questions, and so we'll save enough time for that to happen. But before I begin, I just want to take a second to note the passing this past Saturday of Walter Burns, a longtime AE scholar and former professor of political science and government at Yale, at Cornell, University of Toronto, and last at Georgetown University. Walter, as many of you know, was a remarkable scholar of the American constitutional order and a wonderful colleague and friend. AEI has posted on its website a number of items on Walter's life and scholarship, and it's on the homepage today. And I commend to you the link that's there as well to walterburns.org, which has, among other things, a bibliography of Walter's work, an introduction to his scholarship, and also a biography of Walter. He was quite a scholar and quite a colleague and quite a friend. Now, turning to today's topic, a topic, by the way, which Walter would have found supremely interesting. Ross, if you would mind kicking us off.
Sure. Thank you so much, Gary. Thanks to Bill for being here with me to explain why I'm mistaken, and thanks to all of you for being here as well. I'm actually very grateful to Gary for that framing, because I think the language of constitutionally appropriate is a lot more helpful to my side of this dispute than the strict language of illegality. Because I think that in this issue of presidential discretion on immigration enforcement, you are in an area where it's very hard to bring the issue to so sharp a point on the question of sort of the written material of the laws to prove once and for all that what the president has done is illegal. I think it is very clear, however, that what the president has done is constitutionally inappropriate in the sense of representing a violation of norms of executive power that have existed in many areas, but particularly in this area for some time, basically throughout the entire era of sort of modern immigration policy. And it's constitutionally inappropriate in a way that is connected to a broader pattern under numerous recent administrations, but particularly this one, where you've seen an expansion of unilateral executive authority beyond the arena of foreign policy and deeper than previously into domestic policy arenas as well. And I think that this is something that most people on both sides of the partisan divide tend to concede, that we are seeing in this presidency a great deal of striking creativity, shall we say, in how particular domestic policy areas are dealt with in the face of congressional opposition or congressional gridlock. And this ranges from what you might call sort of defensive operations with the healthcare law, Obamacare, around the individual mandate and the employer mandate and other provisions, where you have sort of temporary bureaucratic suspensions of various elements of the law in order to effectively keep the law working, keep it running effectively in a climate where the administration would be hard-pressed to get congressional fixes. You see something similar, or at least related, in areas related to climate change, greenhouse gas emissions, and so on, where there's been a very creative use of the EPA and related bureaucracies to essentially get a version of carbon taxation, in a sense, although it doesn't work exactly that way, implemented again in the face of a congressional either inaction in the case of the Congresses of President Obama's Congress of President Obama's first 2 years, or simply, again, straightforward opposition in the case of the Congress that's existed since. But I think that the case of immigration is distinctive, which is why I wrote several somewhat shrill columns about it before it happened, and now it's actually happened, so we can talk about it in a less shrill way and analyze it academically. It's different for a variety of reasons, but it's basically different because of sort of an intersecting combination of factors that make this distinctive, unusual, inappropriate, and troubling. And I guess the place to begin, obviously, is with the sort of fact of the existence of a clear presidential reversal on the issue. The fact that this is a case where the executive power being claimed, the power to grant legal status, work permits, and so on to millions of illegal aliens in the U.S. is a power that President Obama explicitly and repeatedly, through surrogates and so on, disavowed in the face of activist pressure during earlier stages of the immigration debate. So you have a situation where, at one point, not so very long ago, while he was President of the United States, not as a senator, not in some previous political incarnation, you have clear statements from the president that this was a violation of his own, to act in this way would be a violation of his own constitutional obligations. And I think it's very easy to see why the president would have read the situation in that way. First of all, it is clearly true that the presidency has wide latitude in certain regards in terms of its enforcement of the immigration laws. And this is the point that Bill makes in his excellent Wall Street Journal op-ed on this subject, and it's a point that's, I think, clear generally. If you go back over the last 40 or 50 years of presidential action on immigration, you find a great deal of unilateral presidential action on immigration in which versions of the kind of legal status that the White House just granted are indeed granted by many different presidents to many different groups. What's distinctive about the current move is twofold. First, the sheer size of the move being undertaken. The estimates of how many people affected range variously, but it's safe to say that it's around 4 million, 3 to 5 million, somewhere in those terms. It's close to half of the entire illegal alien population of the United States. And in that sense, it bears no resemblance whatsoever to the vast, vast majority of the cases cited as precedent. Nearly all of the cases cited as precedent involve discrete, particular, narrow, and small populations of migrants and immigrants who had usually some clear and present situation in their home country that made it impossible or extremely dangerous for them to return. So essentially, you have the use of presidential discretion in a lot of different situations where you're dealing with basically small refugee populations, where sending them back, whether to countries in Southeast Asia or Africa or Latin America, would amount to a kind of death sentence. And you're dealing, in most of these cases, in numbers 25,000, 50,000, sometimes into the hundreds of thousands, but again, nothing comparable to the size of the move being undertaken here. And then that size issue intersects with the level of political controversy involved. The fact that this is not an issue where the president is acting in a political vacuum. It's not an issue where Congress, in some sort of de facto public way, has given the president permission to do this. It's a case where immigration legislation has been hotly debated in the United States Congress in many different situations over the past decade under Republican and Democratic presidents alike, and has repeatedly foundered, usually in the House of Representatives, around some of the very specific issues that the president is addressing head on in this move, for the current and future status of aliens who have come to this country over time, again, not in some particular refugee situation, but over time, and who have come here illegally, usually across our southern border, sometimes overstaying their visas and so on. So it is clearly the case that the president is acting in the face of, in some form, congressional. He's clearly acting in the face of political opposition. He's clearly acting in the face of strong congressional opposition. And so he cannot claim, and essentially, to be filling in some kind of lacuna left by Congress, some kind of opening that Congress has created, and so on. And this is the difference. The only precedent that has been cited that comes close to this one in terms of scale is a sort of cleaning up after action involving families of people affected by the 1986 immigration reform that was undertaken beginning under President Reagan, but really under George H.W. Bush. But in that case, if you look at the situation, if you look at the political context, you were dealing with a situation where there was no clear congressional opposition to the move, where a version of the law was being debated in a much less heated, controversial, and highly partisan environment, obviously, and where there was in effect a kind of tacit agreement by Congress that something like this made sense as a temporary stopgap before Congress actually got around to clarifying the law. Again, nothing like that situation obtains here. It is, again, precisely the population that the president has acted on that is at issue in the heated, ongoing, decade-long congressional debate. So it's that combination, and then I think a third factor that's entering in is that this is a case where the president is clearly using unilateral action and the threat of unilateral action for the sake of political leverage within these congressional debates. And the president has, in fact, repeatedly stated this in public, making comments along the lines of, well, if Congress doesn't want me to act unilaterally, then they need to pass a bill, with the implication being they need to pass a bill that I would like. Obviously, the president isn't inclined to sign the kind of immigration legislation that could pass the House and probably pass the Senate right now without controversy among the Republican majority. And so again, is there any law on the books in the United States that says the president cannot go in front of TV cameras and threaten to act unilaterally in order to affect a congressional debate? No, there's no such law. But in terms of constitutional appropriateness, using expansions, if you will, of presidential authority in order to bully and implicitly blackmail Congress into particular policy actions strikes me as constitutionally inappropriate. And I think that there's a whole lot of sort of lower level policy weeds here that we can probably get into in our back and forth. So I'll save it for then. I guess the only weed that I would raise is just the issue of what you'll often hear this move described as essentially just a recognition of the realities of enforcement policy as it actually exists, right? That the United States has somewhere between 10 and 12 million people here illegally. The United States has, or the executive branch is only provided with sufficient resources to deport some much, much smaller number. The number cited by the White House is 400,000, and you can cast doubt on that particular number, but still concede the general point that there's not the resources nor the political will, obviously, to actually attempt to deport 11 million people, 12 million people, however many. The issue, though, is that, and maybe Bill disagrees and we can get into this a bit, but there's a big difference just in terms of policy between saying we are going to effectively concede that not everyone here illegally is being deported and saying we're going to take affirmative steps that lead to a situation in which they have work authorization. And again, the authority for that work authorization exists. It exists precisely because of in these sort of smaller population situations. If you're telling 10,000 Cuban refugees not to go back to Cuba, you want to give them the capacity to work and so on here. But for the much larger illegal alien population, I don't see any evidence that the purpose of existing law or the intent of Congress has been to say, we're going to have those 11 million stay here indefinitely and have absolutely no sort of labor market costs or everyday costs to their being here illegally. I think it's perfectly reasonable to, in fact, to have an immigration law that says, look, you set enforcement priorities. You aren't going to deport everyone who comes here illegally. But people who come here illegally are going to have to bear some of the consequences of being here without authorization, of crossing our border in violation of our laws and so on. And what the White House has done through this policy is essentially remove the primary burden that illegal status, that violation of immigration law imposes. And I do think that is a much bigger policy shift than simply saying we aren't deporting 6 million, 7 million, 9 million, and so on, or we aren't likely to deport that population. It's the active removal of a burden, not merely sort of the passive observance of the presence of people who you don't have the manpower or the intention of rounding up. So that would be one place where I'd lay a stress on the idea that there is a real policy change here and a much bigger policy change than defenders of the president's move sometimes suggest. But now I think I'll leave off there, and Bill can tell you why I'm terribly mistaken. Thank you very much.
Well, actually, Ross, I'm not going to spend a lot of time telling you either why or even that you're terribly mistaken. And that leads to a broader point. Events like this are frequently billed as debates, Oxford Union debates, hold your position at all costs. Ross said a lot of things that I agree with. And he has already signaled that I have said, and I'm about to say, a lot of things that he agrees with. And the issue of appropriateness, unlike legality or constitutionality, is something that's very subtle, not given to algorithms. And there may be, as John Stuart Mill put it, considerations capable of determining the intellect, but nothing like a proof. It is almost an aesthetic category. So having said that, one other preliminary, that is, I would be derelict in all sorts of duties if I didn't begin where Gary Schmidt did, by invoking the memory of Walter Burns, whom I had the privilege of studying constitutional law at Cornell University 51 years ago. I will never forget that experience, and I will never forget the several occasions here at AEI when I discussed or debated with Walter in the audience. I never knew whether he would agree or disagree with what I was saying. He was a surprising man in all sorts of respects, not easily reduced to any orthodoxy, certainly not any of the orthodoxies in this town. But I can tell you one thing for sure, I always cared about what he thought. As the only Democrat writing a weekly column in the Wall Street Journal, that's not something I can say of everybody responding to what I think, but in but in Walter's case, certainly. So just to put my cards on the table as frankly and as tersely as Ross put his, let me state 6 propositions, some of which engage what Ross said, and some of which are, as social scientists would say, somewhat orthogonal to it, but just to establish some more parameters for the discussion. Proposition number 1 is that the Obama administration's action is consistent with the governing constitutional understanding of the appropriate role of the executive branch. This isn't a lecture, so I'm not going to go into detail, except to point you to the lead case in this area, which was Heckler v. Cheney, handed down in 1986, with an opinion by Justice Rehnquist. And the gravamen of that decision, which I'll quote, is, "This court has recognized on several occasions over many years that an agency's decision not to prosecute or enforce, whether through civil or criminal process, is a decision generally committed to an agency's absolute discretion." Does that mean that it's never reviewable? No. But it means, as the Heckler court went on to say, that there is a presumption of unreviewability. And that points us to something very important about the political situation that Ross adverted to more than once, and that is, this is essentially a struggle between the executive branch and the legislature. And that is the terrain, I suspect, during which this will have to be fought out. Here's my second proposition, that the administration's action is consistent with the governing constitutional understanding of the role of the executive branch in immigration policy specifically. And here the lead case, handed down just 2.5 years ago, is U.S. v. U.S. v. Arizona, with the lead decision by Justice Kennedy, in which Chief Justice Roberts, among others, joined. And to give you the flavor of that decision, here are a few quotations from it. "A principal feature of the removal system is the broad discretion exercised by immigration officials. Returning an alien to his own country may be deemed inappropriate even where he has committed a removable offense or fails to meet the criteria for admission." The opinion continues, "Discretion in the enforcement of immigration law embraces immediate human concerns. Unauthorized workers trying to support their families, for example, likely pose less danger than alien smugglers or aliens who commit a serious crime." And then the court went on to make a very important point, to which I'll return in a couple of minutes. "Some discretionary decisions in this area, namely immigration, involve policy choices that bear on this nation's international relations. The dynamic nature of relations with other countries requires the executive branch to ensure that enforcement policies are consistent with this nation's foreign policy with respect to those and other realities." Okay, proposition number 3, on which I don't need to spend a lot of time because Ross has already laid it out for you very accurately and fairly, is that this action is consistent, and so as not to beg the question, I will say that it is formally consistent, legally consistent, with established executive branch practices in the enforcement of immigration policy. And as Ross indicated, administrations going back at least to the Ford administration have done things of this sort. I'll get to the size question in a minute. The Congressional Research Service published a report in which it found no less than 20 such instances between 1976 and the beginning of the Obama administration. But But let me focus for a minute on the one that Ross singled out. In 1990, the Immigration and Naturalization Service implemented a family fairness program that authorized extended voluntary departure and work authorization to the spouses and children of aliens who had been granted legal status under IRCA. INS Commissioner Gene McNary, this is in 1990 in the Bush 41 administration, estimated that up to 1.5 million individuals were potential beneficiaries. Work authorization, 1.5 million individuals, which leaves as the sole distinction, it seems to me, the issue of political controversy surrounding the issue. And we can get back later to the question of whether the existence of political controversy is or is not dispositive for the exercise of executive authority, which it seems to me is one of the points that you're urging. Proposition number 4, the administration's action is consistent with explicit congressional directives concerning enforcement priorities. And here let me cite just 2. Congress has voted many times, most recently in the 2014 Department of Homeland Security Appropriations Bill, directing DHS to, quote, prioritize the identification and removal of aliens convicted of a crime, and to do so based on the severity of that crime. And as the court has repeatedly noted, the Immigration and Nationality Act reflects congressional concerns about family unification. There's a long policy debate as to whether those concerns serve the country well, but the existence of those concerns on a long-standing basis, it seems to me, is an undeniable fact. Proposition number 5. Given the mismatch between the scope of the Immigration and Nationality Act and the resources available to enforce it, the choice is not between complete and selective enforcement. Selective enforcement is forced on what used to be the INS and is now, 3 different divisions of the Department of Homeland Security. The question is, what kind of selective enforcement? So the real choice is between establishing coherent enforcement policies and proceeding in an ad hoc manner. Those are the only 2 choices. And to give you an idea, the current estimate of illegal aliens in the United States ranges from 11.3 to 11.5 million. Resources available to DHS to engage in removal proceedings at a maximum allow for 400,000 a year. So keep that in mind, 11.5 versus 400,000. The only administration that has ever reached the 400,000 level is the Obama administration, which has done so repeatedly, leading Hispanic activists to dub him the deporter in chief. So this is hardly an instance of abdication of the obligation to take care that the law is faithfully executed. It seems to me that establishing clear enforcement priorities is much closer to what we ordinarily mean by the rule of law than a series of ad hoc determinations. And let me call to the bar in defense of the proposition one Justice Louis Brandeis, who said, and I quote, "The president cannot secure full execution of the law if Congress denies to him adequate means of doing so. The president performs his full constitutional duty if, with the means and instruments provided by Congress and with the limitations prescribed by it, he uses his best endeavors to secure the faithful execution of the laws enacted." Proposition number 6, and this gets closer, it seems to me, to the heart and certainly the gravamen of what Ross put on the table. Because the separation of powers in our constitutional system does not map neatly onto the division of functions, The Constitution is what the distinguished constitutional scholar, the late Edward Corwin, once dubbed an invitation to struggle. And immigration is a classic case of this overlap. For more than 60 years, the Supreme Court has held, and I quote from a lead case in this area, that the exclusion of aliens is a fundamental act of sovereignty. The right to do so stems not alone from legislative power, but is inherent in the executive power to control the foreign affairs of the nation. So we are dealing in the area of immigration with not the executive simply as the errand boy of Congress, but the executive as having a co-equal Article II power as the Supreme Court has interpreted it because of the foreign relations dimension of this issue. As I said earlier, because enforcement decisions enjoy a presumption of unreviewability, the struggle is principally between the executive and legislative branches. As the court declared in Heckler v. Cheney, the danger that agencies may not carry out their delegated powers with sufficient vigor does not necessarily lead to the conclusion that courts are the most appropriate body to police this aspect of their performance. That decision is in the first instance for Congress to make. Which leads me to my political coda. I don't think that it is unreasonable or constitutionally inappropriate for the president to challenge Congress to respond to this action if they don't like it with actual legislation. He has hit the ball into Congress's court, and I think it is now Congress's responsibility to respond. I think it very unlikely that the courts will bail the Congress out. And let me say one other thing in a Madisonian spirit. This great machine that James Madison wrought is in some respects a hydraulic machine. The Constitution, like nature, abhors a vacuum. If one branch is weak and fails to perform its constitutional responsibilities, then the others are likely to move to fill that gap. The solution for an activist presidency is a functioning Congress. It's about time we had one. Thank you.
Thanks, Bill. Ross?
For it must be the offenses come, but woe to the man by whom those offenses come. I mean, I guess I'd working backwards and starting with probably the point of most agreement between us. Mm-hmm. I think it can. Your final point can simultaneously be correct, and it still can be an indictment of President Obama that he's chosen to act in this way. In the sense that yes, our system is a hydraulic system, but it's one populated by human beings with the freedom of action, the freedom not to be to have their decisions simply determined by what vacuums are left, what weaknesses are exposed, what gridlocks and dysfunctions exist. And I think that, again, this is where I see a difference between what's happened here and what's been happening around healthcare legislation, and to some extent what's happened around climate change legislation, though there it is an issue that was always going to be adjudicated by the courts. So you have a certain kind of arbitration available. But here I think you really do have a case of a White House not just responding to what's going on in Congress exactly, but seeing a vacuum and deciding to exploit it in a way that, yes, reflects existing realities of our politics that are, messy and unfortunate in various ways, that reflects internal dysfunctions in the Republican Party that, as you know, I think are unfortunate in various ways, but is also a freely chosen move by a president to dramatically expand both his own power over a certain area of law and policy, but also then by extension the powers that future presidents are likely to claim. And again, in the fact that it's happening in the context of this kind of dysfunction should make us as observers and commentators and analysts willing to say, yes, this reflects dysfunction, but also to say, as I tried to say before the decision was made, that people don't, presidents, this is obviously true in the judicial realm as well, and so on, but politicians and political actors don't have to take all of the opportunities afforded to them for power grabs. And when politicians and lawmakers do take all of those opportunities as presented, when they are not bound by, as they should be, by certain norms and customs and precedents and so on, you can sometimes have a kind of hydraulic effect and things can ultimately balance each other out, but you can also get into a dynamic where essentially the constitutional order just changes, right? And that's what's basically happened in the United States over the last 50 years or 100 years, depending on how you define your terms in foreign policy, where things, like declarations of war and so on have essentially drifted out of the constitutional order. And that's a move that has basically happened, and we just sort of take it for granted. And I'm here in the American Enterprise Institute, and I know there are many people here who think that it's a good thing that that's happened. And sometimes I think it's a good thing as well. I have sort of mixed views on it, but it's a reality, and it's a significant change from American foreign policy as it functioned in certain ways in the past. And I think that if you imagine a situation where something similar happened, as it has to some extent happened on domestic policy, you have to acknowledge that there is a change in the republic that's implicit in some of these movements. And we need to talk about what that change means and just how much power it ends up concentrating in the hands of the executive branch. And then generally, I mean, look, we're living in an age when power in general has moved in different ways to an unelected branch, the courts, and a elected but less democratically accountable in certain ways branch, the executive branch, and away from Congress. And this is a big further step, I think, in that process. And I think, it should be recognized as such, again, even while saying with you, I think that there are many things Congress can and should do to push back against this move and to essentially try and restore a partial balance. So that's sort of a big picture point. And I think, where what's happened since the decision was made both vindicates Bill's point, but also vindicates my anxieties. I think that, you can see, obviously, that the Republican leadership wants nothing to do, really, with pushing back. They want to push back symbolically against this, but they don't want it to turn into a big, extended political debate for all kinds of reasons. And the press, being the press, just sort of moves on. There's another controversy. There's something else happens. I mean, I write weekly or daily. I move on, and that's sort of the reality of how we cover politics, and it's the reality of how politics works. But it means that if you don't have immediate pushback against certain things, they just become locked in. They become precedents. They become part of the political landscape, and that's what I basically expect to happen with this. So that's sort of a big picture. I don't want to take too long. I'll just say very, very briefly about Bill's earlier points. Again, well, 2 points. First, I would stress, as I did a little bit in my opening remarks, the difference between enforcement prioritization and what the administration has actually done. Because the reality is that while, Bill is quite right that enforcement prioritization is both legally acceptable and a practical necessity in immigration policy, that kind of prioritization already existed. It's existed tacitly for administrations for a long time. It existed formally in the Obama White House under the so-called Morton memos, which basically laid out the kind of enforcement priorities that undergird this decision. What it wasn't combined with was the specific statement of deferred action that then enabled the White House to offer the kind of work permits associated with the kind of generally much smaller bore moves of administrations, as Bill says, going back to the Ford era. So again, a decision was made here to go beyond simply the kind of enforcement that the law allows for and that policy requires, to further step that does amount to, I think, a substantive change in actual policy. And again, there's a reason that these issues, work permits, legal status, and their connections are the substance of so many legislative debates. They are the issue under debate in Congress. They aren't a case where you can simply look at the money that's allocated and the way the laws are written and say, well, Congress must have intended for the White House to go ahead and do something like what they did. And then Bill is right that it's a little bit complicated in the one great precedent that is invoked, the George H.W. Bush precedent, because in the end, that 1.5 million estimate turned out to be incorrect, and a much, much smaller number of people actually applied for that status. But that doesn't tell us necessarily that much about this case, because it could be that by that argument, the 4 million estimate, 5 million estimate could be inflated. We'll have to wait and see, I think, how precisely that comparison works. But in that case, I do think that my argument and the arguments of other critics for why that precedent is different from this one does come down to convergence, that you have the convergence of the size issue with the fact that it is a live political debate, a matter of clear controversy. And, if you go, American history is long and complicated. If you go back before the Ford era, you can find immigration law was handled in a very different way, obviously, in the 19th century, with much more direct executive control and very little congressional influence. And we've lived over the last century, Congress has asserted more control in certain ways up till recent eras in a version of that conflict, the invitation to struggle that Bill describes. But you can find cases, in the 1940s, the Bracero program, for instance, was authorized by Congress originally. The authorization lapsed. FDR, I believe, or Truman ran the program for a year or so without congressional authorization. So you can find lots of particular examples where you have the White House doing something without congressional authorization. And you can have one big example, potentially, of the White House doing something big without congressional authorization. But the tendency in all of those cases has been for it to either simply be small, or if it's larger, to be a situation where you have clear implicit agreement of some kind between the White House and Congress, which, again, simply doesn't exist in this case. But I agree with Bill that is certainly an invitation to a struggle, and it's unfortunate that it does not necessarily seem to be forthcoming.
Because because this is billed as a constitutional discussion, let me just, I'd like to respond briefly to the big picture as opposed to the small bore, because I think Ross is absolutely right that the big picture here is what really matters, constitutionally speaking. And 25 years ago, I think it was the American Enterprise Institute that published a book called The Fettered Presidency. And this was a book that faithfully represented the experience that many Republicans and conservatives had, especially in the Reagan administration, dealing with a Congress that regarded itself as plenipotentiary, that was hemming the presidency in on all sides. Now, given what happened in the late 60s and early 70s with the Nixon administration, it's understandable that starting in that period, there was a congressional reaction, which is in a way my point. Congress reasserted itself big time, especially in the area of budgeting, the 1974 Congressional Budget and Anti-Impoundment Act. That was the official name, just so that everybody would understand what it's about. It put the War Powers Act, it enacted the War Powers Act, which no president has ever conceded the constitutionality of, but which remains on the books. Talk about an invitation to struggle. It's an invitation that the Congress has spectacularly refused to accept. And that tells you something about that. But the broader point I'm making is that Ross seemed to be suggesting that the expansion of executive power is a one-way ratchet, at the end of which lies something clearly outside our constitutional tradition. I think a larger view, a fairer reading of our constitutional history is that it's cyclical. And if the executive is seen as having gone too far, not just once, but systematically, Congress will eventually reassert itself, and in the current instance, that reassertion could take the modest form of beginning once again to do its job. And so I do not share the view that this is a one-way ratchet or a linear process. I think that this is the latest act in an ongoing constitutional drama. We've been watching this drama unfold now for 2.25 centuries, and I don't expect it to end anytime soon, nor do I want it to.
As somebody who actually authored one of those essays in the Federal Executive, a reminder of just how old I am. It's good that you've now associated Obama with Nixon's sort of use of executive power. We're running out of time, and I've got 40 questions myself, but that's not fair to you. So what I'll do is I'll identify. Please raise your hands if you have a question. And then wait for the mic, and then also identify yourself. Okay. Wait for me to pick somebody, though.
My name is Samar Chatterjee, Safe Foundation. On one hand, I would agree with most of your proposition, Bill, and especially you come from Brookings, because I consider Brookings to be one of the organizations in Washington who's far more objective than most others, and they consider some of the very outlying ideas. Given that, however, I do share the concern of Ross, which I have found myself when I had my fiancée. I had proposed for her to come from India on a fiancé visa, and this is when the U.S. Embassy did not grant her a visa, and I filed a lawsuit, I was told that the executive branch has unlimited authority to just deny it without a legal review. And I was amazed, and I said, are we living in a country that is run by American Saddam Hussein? Because that is, to me, a complete denial of democracy, and a judicial review should be basic to any decision that the executive branch makes. And that is not there, and that should be ended in whatever way so that our presidents are not Saddam Hussein.
No.
Well, just very, very briefly, your quarrel is with the U.S. Supreme Court, which has established this presumption of unreviewability.
Scott Walter, Capital Research Center. First, thanks for the tribute to Walter Burns, who was a great scholar and gentleman. Mr. Galston, you responded to a lot of the points that Mr. Jalfat made, but I don't think you did much in response to his point that the president himself in previous years not only failed to make these arguments you're now making, but in fact repeatedly contradicted them. Do you want to give us an explanation for his contradictions?
Sure. I don't think it's going to be the explanation that you're expecting, but I think it's a very good thing when presidents are capable of learning something in office. And he may genuinely have believed that his legal authority was substantially smaller than it turned out to be. In the interest of full disclosure, and I said this in the first sentence of my Wall Street Journal piece, when the president did this, took the action that we're now discussing, I was taken aback. And my first reaction was to say, this can't possibly be right, constitutionally speaking. I spent a week doing nothing but reading. And I read a lot of cases, I read a lot of constitutional commentaries, and I came to the conclusion that, setting aside for 1 minute the question of appropriateness, which I think it's appropriate to raise, by the way, that the president was on much firmer legal and constitutional ground than I had understood. I have no factual basis for answering the actual historical question that you put on the table. What is the explanation for this? But it is at least possible that the president, after a year of dialogue with Jay Johnson, was led to the conclusion that his authorities were considerably broader. Now, the cynics can introduce a political interpretation, which for all I know is the correct interpretation. That's the best I can do with your question.
I mean, I would just say briefly, I'm quite confident that the president does not see himself as a cynic on this matter. I'm sure that he believes that he genuinely changed his mind upon serious consultation with his lawyers, as presidents tend to do in these situations as their terms in office continue and congressional opposition mounts. I would only say that I think that distinction between the sort of initial commonsensical reaction, both from Barack Obama himself and from Bill, and what you can be persuaded of upon wading through case law and so on, is often a good way of telling when you're doing something that is arguably technically legal, but constitutionally inappropriate.
Can we follow up on that a bit? I want to, and this question for both of you. So if I understand correctly, I mean, in some sense you're arguing something can be plausibly legal, right? But that the president's larger responsibilities to sort of faithfully execute not just a law, but the laws can be undermined. And so in fact, something can be legal, but in some sense constitutionally dubious.
Well, what I'm conceding is that there's clearly a gray area, right? And the court's own language says as much, that basically you have sweeping prosecutorial discretion, but there's clearly some point at which prosecutorial discretion would become an effective rewrite of the law. We're not saying where that is, and the presumption is that it's unreviewable, right? I mean, that's basically sort of the legal status, and then there are a lot of secondaries. So then the question becomes, what is the point at which prosecutorial discretion becomes a rewrite of the law? And what's interesting is, you end up with lots of different answers. The Office of Legal Counsel came up with an answer that was actually quite different in certain ways from the answer that a lot of liberal defenders of the president was giving. They said this move was okay because you're dealing with parents and relatives of people who will, who are birthright citizens, and so under existing law, those people can apply for citizenship once their children are adults. So they do have at some point the prospect of a permission to apply for citizenship. So it is a defined category of people that Congress has already taken into account, so it's okay. Then the implication in there, they didn't say this, was that actually the smaller, the DACA, the Deferred Action for Childhood Arrivals, was more dubious because you didn't have any sort of congressional warrant there. They didn't say this explicitly, but that was, I think, one way to read between the lines of the OLC memo. Now, does that make sense? I mean, you can come up with lots of different ways to cut the specific issue of legality, and I think that a smart lawyer, of which I'm sure there are some in this room, would be able to.
Well, there's lawyers.
There's lawyers. I said this in I think the first column I wrote on this, that undoubtedly there would be legal arguments made in its favor by smart lawyers. I think that's again partially why I just think it's useful to step back to the broader constitutional question and say, well, what does this look like? Does this look like a sort of modest, does this look like a modest exercise of prosecutorial discretion, or does it look like a White House using the fig leaf of prosecutorial discretion to change immigration law? And I think it looks more like the latter.
Well, on that point, because I was follow up on that, I actually think the legal counsel memo actually is quite interesting in that regard, because I think, in fact, they're uncertain about exactly where this is headed. So, for example, just a quote, The breadth of such programs may raise concerns about whether immigration officials have undertaken to substantially change the statutory removal system rather than simply adapting its application to individual circumstances. Then they go on to say the guarantee of individualized case-by-case review helps avoid these potential concerns, and that the executive is not rewriting the law. The question then that they sort of implicitly raise, and I guess as Bill this, is it credible that in fact this case-by-case part of the immigration decision is actually, well, is it credible given the fact that in previous decision on the immigration to let the students in, it's been something like on the order of 97% approval. So isn't the possibility that in fact, again, the president has a plausible legal argument based upon executive discretion, but in fact he's using it in such a way as actually to overturn the clear intent of the larger law?
Look, as Ross, I think, rightly and fairly said, this is a gray area. It's also not the first time in American history that a determined president, or for that matter, other determined branches of parts of the Constitution, have moved in a manner that cannot be described as restrained. And Ross's plea is for constitutional restraint. The distinction between what it is arguably possible for you to do constitutionally speaking and what you actually do. It is absolutely correct, and I want to underscore this, that actors in this Madisonian system are not determined beings. They make choices within this system. The fact that a void of power and policy exists in a particular area is an invitation to occupy it. It is not a command, let alone a Newtonian force pushing you inexorably to do it. Although, by the way, there's a lot of Madisonian language that verges on the proposition, as you know, that the libido dominandi is such that it is very, very likely that given the absence of resistance to the exercise of power, that the power is very, very likely to be exercised, which is where your constitutional and theological interests perhaps converge. So, yeah. And
That'll be panel 2.
yeah, but let me just once again declare my faith in the constitutional process writ large. That is, the faith that if there is strong, perhaps excessively strong according to some standards or according to some branches, action by another branch, that this will evoke a constitutional response. And I don't think that the president's action is pathological, but I do think it is in part a response to something that is pathological. And we urgently need a Congress that is prepared to get to yes, not necessarily on what the president wants, but on something it wants, right? One of the most startling facts, it seems to me, about the 113th Congress, and please someone correct me if I'm wrong, is that not a single immigration bill was actually voted on by the full House. The idea was that this would be broken up into pieces and the House would vote on them individually. If the House voted on any one of these pieces individually, it escaped my attention. And that in the face of a Senate bill that was supported by nearly 3/4 of that body. So something is wrong here, and it needs to be put right, and I'm not saying it's the president's sole responsibility to put it right.
But how do you determine when, there have to be moments in the American political order when you have democratically grounded resistance to a particular course of action that leads to gridlock, right? I mean, gridlock has to be, it's not inherently a failure. Gridlock is not inherently a failure of Congress. And again, I agree with you. We could have a long love fest about problems within Congress and within the Republican Party. But just going issue by issue and saying, well, there hasn't been congressional action on this, or the House is opposed and the Senate is supportive on that, I don't think that that tells you anything absolute about whether a particular issue somehow needs to be addressed. And the one, this isn't quite a response to your point about whether we're dealing with a ratchet or some sort of inexorable ascent of executive power, but one of the patterns of American history has been that it's not so much that executive power in particular, moves to fill vacuums. It's that executive power responds to crises, particularly foreign policy crises, but also sometimes domestic ones, where swift action is clearly necessary. And sometimes it overreaches in taking those actions, and then after the emergency passes, you end up with a sort of, a ratchet back in reverse. And this happens frequently with civil liberties, obviously, in our history. But also, with issues related to war and peace generally. And one of the striking things to me, again, about this issue especially, is that there isn't a crisis. I mean, this is not a situation. Obviously, activists involved in the immigration issue argue that there's a crisis and so on, but there isn't a crisis in the generally agreed upon sense that there was a crisis in the U.S. in 1861 or after Pearl Harbor or something, I think. And so you are dealing much more with presidential action that isn't clearly crisis driven. Or I don't think you could necessarily, if you look at public opinion polls, right, and not necessarily reliable, but public opinion does not support the proposition that immigration is the single issue that Congress needs to be focused on most right now. I guess that's just another reason for concern about the way in which this move is being made. And it's different too. With climate change, at least you can argue the view that if you really believe that the worst case projections 50 years hence, there's a sense in which executive action on those issues is a matter of sort of the not immediate, but a matter of the long-term survival of the United States. But nobody really believes that about these immigration policy matters, I think.
Let's take a couple more questions, please.
Sorry.
Hey, Gerald Chandler here. I'd appreciate your trying to apply this to another case about prison sentencing. The Attorney General has said that we have too many people in jail for too long. Suppose that the President simply said that everybody who has served half of his sentence time got commutation and was let out of jail. That seems to me well within his power, but would that be going too far? How would you analyze that case along the lines that you've already analyzed the case of immigration?
Is that addressed to me? The answer to your question is that I'm not going to be so glib as to answer a question about which I know nothing on national television. That I was led to the views that I articulated about immigration policy through a sustained immersion in an area about which I had previously known very little. I know even less about the criminal justice system or the respective powers of the executive branch, the legislature, and the judiciary in this area, there are some analogies between prosecutorial decisions and enforcement decisions, and between immigration enforcement that is seen as punitive and criminal enforcement, but the courts have a very, very different view of those two sets of issues. Among other things, the presence of being present illegally in the United States is not a criminal offense, strictly speaking. So there are all sorts of issues I'd have to sort through for myself before I could even venture to respond to your question. I mean, it's a fair and interesting question, but I think I have good reasons not to answer it right now.
I would just say briefly that I think it's generally understood, and like Bill, I would need to spend a lot more time before I was absolutely confident of the answer. But it is generally understood that the pardon power is one of the most sweeping powers that the presidency is clearly granted, and that it therefore is a clear case, clearer in some ways than these issues, where you have a potentially sweeping power constrained more by norms than by the Constitution itself, which is why the last major exercise of pardon power, going back to the 70s and the Vietnam War and Jimmy Carter's pardon of draft dodgers, was so controversial. But I think it's an area of, I agree with Bill that there are a different set of legal issues probably in play there, but it is also a case, I think, where the constraints of norms matter a great deal.
You know, as a veteran of the Clinton administration, I can also tell you that the pardon power can be abused in a much more particularized way.
Yeah, no, it's an interesting issue, whether the pardon power is actually as plenary as people think, because it's also bounded by the president's oath, and so, and his obligation to faithfully execute the law. So,
but there's a gray area there.
No, absolutely,
right.
no, and the Constitution doesn't say duty; it just shall or something. Please wait for the mic, please.
Thomas Ward, I'm an economist. I'm trying to understand a couple questions. One, define what is legal and what is illegal. Secondly, if you have a rule of law, but you're enticing people to be quote unquote illegal, how do you expect people then to follow the laws? Then finally, with ID law, is that a federal or a state issue coming into play?
Sorry, what was the third? What was
ID law, if you're abusing the
Oh,
IDs.
ID law.
It's a state matter, typically, because it's typically tied to your driver's license. So once you have a work permit, then you can go to the state and typically get an ID.
That's how it's usually played out, and the understanding. But it varies. There's a lot of. I mean, I think there's some pending judicial.
No doubt.
Court cases going on about the driver's license issue, and I honestly don't know exactly how they intersect, but my general understanding has been that work permits make it a lot easier to get driver's licenses, basically.
There is, it seems to me, in this ID area more broadly, there is a federal dimension. For example, I don't think it's outside the purview of Congress and the executive branch to insist on the use of systems such as E-Verify for employment status. So, and that in turn will require whatever forms of identification are deemed to be acceptable and binding in that area, so that employers can actually rely on that. So it's not simply a state matter.
I follow up on that because I'm not now that the ruling down in Arizona today, that the judge down there was saying they can't enforce an immigration law because of ID law, because they were stealing IDs to come in. And then you're enforcing federal law on the back end, because now they're using that to get work. Is that complex? And then the other question comes into it, you're just saying how the Congress hasn't acted. Well, sometimes when the Congress doesn't act, such as even back 6 years ago when the Democrats had both sides and didn't act. So why all of a sudden the push now they should act?
Well, we were having a constitutional discussion, and I think that would take us into some very sad political history. But I think it is perfectly fair to say that the democratically controlled Congress did not act on this question when it had the power to do so, and for all sorts of reasons, I think that was an extremely regrettable omission.
Yeah. Ross, let me ask you, running out of time, but ask one question. I mean, conservatives obviously are unhappy with not only this decision or this immigration decision, but a previous one, and then also things having to do with the Obamacare mandates and the like, environment as decisions, regulation decisions, you said. But isn't this just a really, in some respects, just the product of the fact that conservatives haven't won the battle when it comes to the administrative state. Isn't the reality of executive power the reality of the fact that for past 100 years, the administrative state actually has sort of superseded the original constitutional framework, and that we're just living in a political and quasi-constitutional system that the framers never intended or anticipated. So, isn't the conservative?
I mean, yes, but where do you? But what I guess what follows from that? Because I think it is. I think even within a situation where you have, basically the administrative state by its nature creates many more gray areas than certain ways previously existed. But I don't see, I guess, a conservative plan to roll back the administrative state generally is unlikely when the conservatives can't even pass an alternative immigration bill. So that, I think that when we're talking big picture, and this is where I do disagree with Bill, I guess, I do think that there's been something more than just a sort of back and forth. That, if you look over the course of the 20th century in foreign and domestic policy, the presidency has gained power at the expense of Congress. And that's happened for all kinds of reasons related to congressional abdication, related to the nature of the administrative state, related to the way certain crises have played out, related to the Cold War, you name it. And there have been moments when Congress has pulled back sharply, as they did after the Nixon administration. But I do think the general trend is pretty clear, and it's correlated in certain ways with judicialization as well. So I think it's important to acknowledge that general trend, and issues like the growth of the administrative state play a big role in the trend as a whole. But when you're dealing with sort of particular issues, you still have to figure out what the particularities of them are. And it's sort of, you can't just say, well, this is an inherent problem with the administrative state. It is, at the very least, an inherent issue with it. But that doesn't, if you're opposed to what the president is doing, you don't necessarily solve the problem by making it bigger.
That's perfectly true. And I can see how wise I was to spare the assembled company my 50-minute lecture on the Administrative Procedure Act. Having said that, I'll now give you 1% of it, and that is that the Administrative Procedure Act, passed in 1946 after nearly a decade of deliberation between the parties and between the branches, represents the nearest thing we have to the constitutionalization of the administrative state. It doesn't take the form of a constitutional amendment, but in effect it constitutionalizes the first half century of the reality that Ross pointed to. And one of the striking things about the current controversy is how consistent the administration's actions have been with a fair reading of the Administrative Procedure Act. And I'm not going to go into chapter and verse on that, but it is an addition.
I'll have to go read it.
It is an additional. Well, by the way, it's one of the long poles in the heckler tent, as you'll see, or have seen already. But I digress.
I suggest reading it at night when you can't go to sleep. We've run out of time. I want to say that, as opposed to the Constitution, which, as Corwin says, is an invitation to struggle, we've had a very deferential discussion here, which I really appreciate. And would you join me in thanking Ross and Bill for their fine contribution?